Hello, this is John Milburn from Central Queensland University. Today's session relates to the issue of legal reasoning. During your studies, you may be called upon to identify the legal test applied by a court when coming to a decision. To identify the legal test, you need to consider appropriate legal reasoning. And when you describe the legal test, you are essentially describing the logical analysis of the decision. In other words, what test did the court apply in coming to its conclusion? Now, when I speak about the legal test or tests, you will need to consider several things. What is the key legal issue for determination in the case is one of those. And when we talk about legal issues, you might recall from your sessions on legal logic, closely aligned to legal reasoning, the IRAC test, where we consider the issues, then the rules, then the application, and finally the conclusion. In terms of legal reasoning, I think that it's appropriate to add something further, and that is at the start to consider the material facts upon which the legal issues are based. So when considering legal reasoning, I think it's appropriate that we start by determining what are the material facts in a particular case. This is closely aligned with the issue of identifying the legal issue because the two work together. So in that context then, a common method of determining legal reasoning used by lawyers and used by judges can be described by applying the acronym MIRAC, which is IRAC with the M in front. So MIRAC, M-I-R-A-C. That is the material facts, the issue or issues, the rule or rules, then the application, and finally the conclusion or conclusions. It's a good way to look at a case, and often judges write in a manner that follows the MIRAC method. You might consider doing that also in your assessment work. But a word of warning at this stage: do not slavishly follow the formula. I certainly don't like to read essay work which slavishly has headings of material facts, legal issues, legal rules, application, and conclusion. It may be appropriate in some circumstances, but sometimes it simply doesn't fit neatly to the manner of writing your assessment. And therefore, slavishly following this in terms of an outline of how to write an answer can actually be a negative, and you might find that you're trying to attempt to put a square peg in a round hole, so to speak. But in terms of legal reasoning, legal logic, it should always be at least in the back of your mind, and you should consider it generally, if not directly, in each case. If you look at cases, judges may often set out their judgment in that manner. The judge may identify the material facts in a case, perhaps in the context of a general background. The judge may then identify the legal issue, and the legal issue might be described in a brief statement or in an extensive overall statement of the law. The legal issue might be, for example, this is a breach of contract case. Now, the judge may not actually say that, so you may need to read that into the judgment in the same way that you might have your assessor read that into the work that you produce. But it's always there. You need to identify and work around the legal issue. Step 3, identify the relevant legal rules. Primarily statute and common law, and in that order, generally speaking, but not necessarily. And the legal rules may go beyond statute and common law. It may be that you look in terms of international obligations, treaties, conventions, things of that nature, or you may look at secondary materials such as the writing of texts, textbook writers, or in terms of statutory interpretation principles, things like second reading speeches and extrinsic materials such as explanatory notes or explanatory memorandum. Step 4 is where you apply the legal rules to the facts. And step 5 is a statement of the conclusion. In reality, much of a judgment will be encompassed in step 4, that is the application of the legal rules to the facts. But you may not find that the judge writes in that particular order, and it may be that these 5 steps are blended somewhat seamlessly throughout the judgment that you're reading. But you can identify them, and you need to identify the legal issue or issues. So applying that logic then to how you deal with the issue of legal reasoning when answering an assessment piece, the first thing is that you must identify the material facts. You must do that in conjunction with identifying the legal issue or issues. And this is, of course, relevant to the particular case that you have before you. In an ideal answer, you would state the material facts upon which you rely and upon which the rest of the assessment work that you write about is based. Sometimes it is relevant to identify the red herrings in writing an assessment answer, but you don't need to do that. Particularly if you're asked to analyse a matter, you must consider that which is missing. And if you believe that there are material facts which will exist but have not been identified in the question before you, it's very wise to identify that fact that there is something missing from the assessment, and that therefore the answer you give is relevant only in relation to the facts that you're aware of. Another way of dealing with this is to identify what you believe to be an appropriate presumption or assumption as to material facts, and answer your question in accordance with that assumption or presumption, as the case may be. And make that a clear statement that you are providing the answer and dealing with the legal issues on the assumption that X, Y, Z applies. So once you've identified the legal issues, which involves identifying the material facts and identifying those material facts that have not been stated and that need to be obtained, you are effectively stating what a court would consider. It's at that stage that you need to identify the legal rules. And as I've mentioned, that will be a combination generally of legislation or case law or both. You do not need to name every piece of legislation or every case referred to by courts in coming to its decision. So, for example, if you're providing a case note or case review, you don't need to identify every section, regulation, rule, practice direction, or case upon which the court made its decision. A case summary or case note, for example, requires you to be selective in that regard. And if you're writing an assessment piece in response to in response to a question to provide an answer as to the likely legal scenario in the case, you don't need to mention every case that has dealt with the section that you refer to as being relevant to answering the question. In fact, that can be a negative. Generally speaking, provide the leading case and leave out those cases which simply apply the leading case or the logic or principle behind the leading case, which is essentially what you're doing in answering the question. When writing assessment pieces and therefore marking the assessment piece, I do not necessarily have a strict template in terms of every piece of legislation or every relevant case, because some students may identify particularly some cases that they believe are better illustrative or relevant to the particular circumstance than another case. What is important, though, is that when you're reviewing a case or when you're writing an answer for an assessment piece, you are able to demonstrate your interpretation of the statute and case law around which your answer is based, and that you can identify that which is important in the particular matter before you. So, coming back to the original premise of legal reasoning and determining what process a court adopts when answering a case, what you need to do is, in essence, decide how the court applied the law to the facts of the case, steps 4 and 5. But in doing so, you need to at least incorporate steps 1, 2, and 3, as I've stated them in the Mirac matter. Now, in the conclusion, what you need to do is state a description of the legal process, the legal reasoning used by the court to reach its conclusion. The conclusion that you arrive at in relation to a legal problem may be quite different to the conclusion that I arrive at in considering that same legal problem. However, you could still secure top marks even though your answer is completely the opposite of my answer, because what I'm really concerned about is your process of legal reasoning and correct identification of the law. Different people will apply the law in the same scenario in different ways. You can see that in High Court decisions where the court is regularly split in terms of its decision. It might be 4-3. That doesn't mean that those who are in the minority don't know the law or got it completely wrong. Quite the opposite. It's just that at that critical stage, those judges went one way, other judges went a different way. So ultimately, your task can be summarised in this manner when you're doing a case review or you're applying the case law and legal reasoning to a legal question. Firstly, in relation to a case review, why did the court come to its conclusion? And if you're answering a question, why did you come to your conclusion? Either way, to answer the question or write an appropriate case note, you need to go through the legal process that I have described. Thank you for listening.